Get ready for the dictation. Start. We have heard learned counsel for the parties and perused the material on record. Stop. Para. Learned counsel for the petitioner has contended that the impugned order is violative of the principles of natural justice, as he has not been afforded any opportunity before passing the impugned order. Stop. Hence, the impugned order deserves to be quashed. Stop. Para. The learned standing counsel, appearing on behalf of the respondents, urged that the impugned order has rightly been passed and the license issued in favor of the petitioner could have been cancelled at any time. Stop. In the circumstances of the case, he urged that the petitioner is entitled to no relief from this court. Stop. Para. Impugned order reveals that the decision to restore the license of the respondent number 4 has been taken on the plea that on the date license was cancelled, it was allotted to the present petitioner on the same day. Stop. It is also stated that the husband of the petitioner had also filed a complaint against respondent number 4, leveling certain allegations against him. Stop. The order proceeds on the assumption that a conspiracy seems to have been hatched against the respondent number 4 in order to have license allotted in favor of the present petitioner. Stop. While construing the import of the order, it clearly emerges that the appellate authority did not take into consideration the allegations against the respondent number 4 and also the finding recorded by the same appellate authority in this behalf. Stop. It is pertinent to mention here that while rejecting his earlier appeal, the appellate authority vide its judgment dated 24th December, 2008 found that the license issued in favor of the father of respondent number 4 was never renewed, as it did not bear the signature of the competent authorities, that in the renewal order one more item of the tractor was also added which was not in the earlier license, that the excess tahbajari was recovered by the respondent number 4, that the land situated at Gata number 158 was not sufficient for conducting of the market, as it was recorded in the order that there were 23 shops and residential houses over the said land. Stop. Para. Impugned order passed by the appellate authority was required to go into these questions after hearing the parties. Stop. Instead of addressing itself on these issues, a new theory has been expounded that the license of the respondent number 4 was cancelled on account of conspiracy hatched by the husband of the petitioner with the prescribed authority. Stop. This per se is perverse finding. Stop. It may also be noted that the appellate authority was to deal with the correctness of the order of the cancellation issued against the respondent number 4. Stop. Without addressing the merits of the issues raised, it has travelled beyond the scope of direction issued by this court by examining the legality of the license issued in favor of the petitioner. Stop. Direction of the court was to hear the parties afresh and pass appropriate order. Stop. The very nature of the direction circumscribed the area of controversy which was required to be determined by the appellate authority. Stop. Appellate authority has absolutely misdirected itself in travelling beyond the direction of the division bench. Stop. As already stated herein, the finding recorded by the same appellate authority in which certain findings were recorded against the respondent number 4 has not been examined, and it was the correctness of that order which was required to be re-examined by the appellate authority as directed by this court. Stop. There is one more aspect of the matter, that respondent number 4 on his own has requested the prescribed authority to allow him to hold the cattle market on Thursday, which plea has been accepted. Stop. After having accepted to hold the cattle market, it could not have raked up the issue seeking cancellation of the order by which license has been cancelled. Stop. He was stopped from questioning the order of cancellation of license when, on his own admission, he had accepted to hold the market on Thursday instead of Monday. Stop. Para. For the reasons stated above, the writ petition is allowed. Stop. The order dated 24th June, 2011 is hereby quashed. Stop. There shall be no order as to costs. Stop.